Good afternoon, everyone. I hope you can hear me. Thanks for joining us for the next in the Beale Company series of construction law updates. This time, the subject has an Irish theme, the Construction Contracts Act 2013. As many of you will know, this has been given a commencement date of 25th July 2016, so it is particularly topical. For those of you who don't know me, my name is Cathie Shannon. I'm an associate in Beale Company. I'm joined today by Tom Pemberton and John Henderson, who will be familiar to many of you. They are both partners in Beale Company, specialising in construction. Before I start, just a brief word about the structure of this webinar. It is proposed that I provide an overview of the Act and its application, and touch on some of the outstanding issues and unknowns. Tom Pemberton will then speak about the sections in the Act dealing with payment and suspension for non-payment. John Henderson will talk about the practical experience of adjudication. Before I begin, just a reminder about the usual housekeeping items. During the webinar, you can submit questions to us in the appropriate box on the right-hand side of your screen. Depending on the volume of questions received, we will deal with some of the more interesting questions after the webinar has concluded. If possible, can you please mute your microphones? I will be providing an overview of the Construction Contracts Act 2013, particularly the provisions relating to interpretation and its application. In this talk, I will refer to the Construction Contracts Act 2013 as the Act. The talk will involve my providing an overview of the legislation, identifying the construction operations and construction contracts to which the Act applies, identifying the exceptions to the Act and some outstanding issues that require to be addressed before 25th July 2016, the commencement date of the Act. This Act, a relatively concise piece of legislation comprising 12 sections and a schedule, introduces a number of significant changes for those in the construction industry in Ireland. The Act's first purpose was to provide for the inclusion in construction contracts, as defined in the legislation, of provisions to address the amount and time frame for payment of interim and final payments. The primary intention of this was to outlaw the pay-when-paid clauses often included in subcontracts. Sections 3, 4, 5 and 7 and the schedule are the provisions relating to payment and suspension of works. These will be dealt with in detail by Tom Pemberton. The second purpose of the Act was to provide for the introduction of statutory adjudication for disputes relating to claims for payment. This is dealt with at Section 6 of the Act, which provides that a party to a construction contract has the right to refer for adjudication any dispute relating to payment arising under the construction contract. The practical experience of adjudication will be dealt with by John Henderson in his talk. The Act cannot be contracted out of. Section 2, subsection 5 makes clear that the parties to a construction contract cannot limit or exclude its application by, for example, making the law of another jurisdiction the governing law of the contract, or by purporting to include terms that limit the Act's operation. Territoriality is not expressly dealt with in the legislation, but it is likely to be confined to Ireland. The introduction of the Act was driven by the plight of the subcontractor, many of whom went to the wall in the recession as a result of not being paid. This legislation was 6 years in gestation, and its slow progress had led many to suspect that it might not see the light of day. It is largely modelled on the equivalent UK Act. The Housing Grants, Construction and Regeneration Act 1996 in the UK similarly outlawed pay-when-paid clauses and introduced adjudication. Insofar as adjudication is concerned, the legislature in Ireland considered a number of models in use internationally, including those in various Australian states. At Section 1, there is a very detailed definition of construction operations. The definition of construction operations merits careful consideration for anyone in the industry, as the application of the Act is to contracts for the carrying out of construction operations. It is very broad. It includes almost any activity associated with construction that one might think of at all stages of a project, from site clearance through to painting and decorating, maintenance and repair. Temporary works are covered, as are demolition works. External and internal cleaning in the course of construction are included. Maintenance and dismantling of scaffolding are covered, as are the installation of fixtures, fittings and M&E systems. Projects of all kinds are covered by the definition, from aircraft runways to pipelines, docks and harbours. The definition of construction operations borrowed heavily from the pre-2009 UK Act, and internationally there is a fairly uniform definition of construction operations. However, the Irish Act includes some points of interest. Traffic management operations are covered by the Irish definition, whereas these are not mentioned in the UK. In addition, the making, installing or repairing of sculptures, murals and other artistic works that are attached to real property is included as a construction operation. This provision is unique to the Irish legislation. There are several references in the definition of construction operations to construction operations being works to structures or buildings or fixtures and fittings that are to form part of the land. There is case law from the UK considering this phrase in the context of the equivalent UK legislation. In the UK, it has been held that to be legally fixed or affixed to the land as a fixture, an object does not need to be actually fastened to it. An object that rests on the land under its own weight, without mechanical and other fixings, can still be a fixture. This is generally a question of fact and intention. See, for example, the UK case of Savoy and Spicers from 2014. The definition of construction operations is clear that it does not include the manufacture or delivery to site of materials, equipment, plant, machinery and components. However, manufacture and delivery contracts are covered if the goods are being supplied or manufactured on foot of a contract that also provides for their installation. Section 1 of the Act defines construction contracts as including agreements between an executing party and another party, whether oral or written, for the carrying out of construction operations by an executing party. Where the parties to the construction contract are contractor and employer, the executing party is the contractor. Where the parties to the contract are main contractor and subcontractor, or two subcontractors, the executing party is the party who is carrying out the works under the contract. The definition of construction contracts includes arranging for the carrying out of construction operations by others, whether under subcontract or otherwise. The definition also includes agreements for the provision of labour for the carrying out of construction operations. The definition of construction contract includes agreements to provide work and services that are ancillary to construction contracts. The Act specifically mentions architectural and engineering services, project management, surveying, landscaping, interior and exterior design. Therefore, consultants should be aware that their contracts with employers meet the definition. Consultants will have to bear this in mind when considering their own terms and conditions. Importantly, if consultants engage sub-consultants, the Act will impact on those sub-consultancy agreements as regards the timing and amounts of payments due. These will be treated as subcontracts, which are subject to more favourable terms than the main contract. That will be dealt with by Tom Pemberton in his talk. At Section 2, subsection 1, the Act defines contracts that are not construction contracts for the purpose of the legislation. First, where the value of the contract is less than €10,000, the contract is deemed not to be a construction contract. This means that certain smaller jobs will fall outside the ambit of the legislation and the requirements of the Act will not have to be met. Many of these will be small domestic type projects. There is a second exception that applies to contracts that are only for dwellings and the floor area is no more than 200 metres squared, and where one of the parties to the contract occupies or intends to occupy the dwelling as his or her resident. Contracts that satisfy all these requirements will fall outside the scope of the Act. Keep in mind that this domestic dwelling exception would allow for a situation where the main contract between a homeowner and a contractor falls outside the scope of the legislation, but a subcontract on the same job falls within the ambit of the legislation. This would arise as, in the case of the subcontract, neither of the contracting parties would be the homeowner, which is needed in order to avail of this exception. Section 2.2 provides that a contract of employment is not a construction contract. A third exception applies to contracts between state authorities and their partners in a PPP arrangement. Such an agreement is not deemed to be a construction contract for the purpose of the Act. However, keep in mind that even where this PPP exception applies to the head contract, a subcontract on the same job may still be a construction contract. The position that works by a subcontractor may be covered, even where the main contract works are excluded, has been endorsed by the UK courts. See, for example, the Cleveland Bridge versus Wesser Volker Steven decision from 2010. As provided for at Section 8, the Minister for Jobs, Enterprise and Innovation has selected and appointed a panel of adjudicators, 30 in number. This panel has been in place since December 2015. The chairperson is Professor Niall Bunny, who will be well known to some of you with experience of construction disputes in Ireland and further afield. In fact, the chairperson was selected before the panel, which was not what was anticipated by the Act. If you look at Section 8.1 of the Act, it provides that the chairperson is to be selected from amongst the panel, and that's not what happened. The chairperson of the panel is to appoint adjudicators to disputes that have been referred for adjudication in the event that the parties to the dispute fail to agree this themselves. Panel members include lawyers, architects, engineers and surveyors, and a number of them have experience of adjudication from practicing in the UK. For the most part, the Irish panel members started out as arbitrators and have undertaken conversion courses to enable them to take up panel appointments. The Act actually confines panel appointments to a number of professions, including those just mentioned. Section 8 provides that the Minister is to have regard to an applicant's experience and expertise in dealing with construction disputes when considering whether to make an appointment. One issue that has been the topic of discussion is whether members of the panel ought to be allowed to act as claims advisors as well as panel members. The application form for panel membership contained reference to the fact that the applicant would undertake not to advise in relation to disputes where other panel members were adjudicating the dispute. That would rule out panel members advising in relation to many adjudications. For this reason, a number of well-known persons in the field of dispute resolution did not apply to become panel members, and it remains to be seen whether this will be an issue. The Act allows the Minister to remove members of the panel for good and sufficient reason. Appointments to the panel are for 5 years starting from 8th December 2015. A comment one might make is that some panel members are not young, and the 5-year term is quite lengthy taking into account their relatively advanced ages. A code of practice governing the conduct of adjudications has been legislated for at Section 9 of the Act. This code has still not been signed into law by the Minister, but it is thought to be in its final form. It has been described as shoring up deficiencies in the primary legislation. Presumably it will be signed into law before 25th July 2016, the commencement date for the Act. The final requirements to ensure smooth implementation of the Act are a code of conduct for adjudicators and new rules of court. We have yet to see the draft code of conduct for adjudicators, and it's uncertain exactly what it will include. The further step that will be required is the amending of the rules of the superior courts to take account of the introduction of adjudication. As matters stand, it's not clear how an adjudicator's decision is to be enforced should this be necessary. It is hoped by many in the industry that a number of adjudication judges will be appointed, much as we have a number of specialist arbitration judges. It's also hoped that the procedure adopted will enable the courts to deal with enforcement applications in a timely and effective fashion, without which adjudication may lack teeth as a procedure. Those of you with experience of the Irish courts will be aware that speed and efficiency in disposing of litigation have not been its hallmarks. The absence of a procedure that will allow enforcement applications to be disposed of in a relatively short time frame may ensure that there is little incentive for a party to pay on fruit of an adjudicator's decision. Another impact that may be felt is in the insurance industry. In the UK, claims against consultants for professional negligence are dealt with at adjudication. Construction PI policies in the UK market typically provide that if an insured is served with a notice of intention to refer a claim for adjudication, it must be notified to insurers within 2 days. the Irish legislation does not provide for professional negligence claims to be referred for adjudication by an employer. However, the procedure will allow issues of negligence to be raised in defence to a claim for payment, such that a situation may well arise where a consultant or contractor who has PI cover may be obliged to deal with these allegations in the context of adjudication and notify a claim or circumstance depending on the allegations made. The 28-day adjudication timetable may impose a considerable administrative burden on all concerned with such a claim. Insurers in the Irish market may consider that their construction PI policies require to be amended to allow for early notification of circumstances or claims made in connection with an adjudication. This is something that may be seen in the coming months or years. A final point that's worth raising is the fact that the concept of adjudication does not sit well with our constitutional rights. The constitutional backdrop was touched on by Mr. Justice Frank Clark of the Supreme Court in a public lecture at Engineers Ireland on 29 January 2014. Articles 40.3.1 and 40.3.2 of the Constitution provide that the state has to vindicate the personal and property rights of citizens. The concept of judicial decisions being made by bodies other than the judiciary is expressly allowed by Article 37. There are various other examples that can be pointed to, such as the Financial Ombudsman and the Planning Board. However, there is invariably a right of appeal, and the decisions are not enforceable pending the outcome of the appeal. It is this aspect of the enforceability of an adjudicator's decision given in haste that makes adjudication different and a bit suspect from a constitutional point of view. Back in 1999, the leading UK case of McCobb Civil Engineering and Morrison Construction. In that case, the judge was faced with whether to uphold an adjudicator's decision, which one party contended was invalid and made in breach of principles of natural justice. The judge made clear that it was intended by the legislature to introduce a speedy mechanism for settling construction disputes on an interim basis, and that the decisions of adjudicators were intended to be enforceable pending final determination of the dispute by arbitration or litigation. The judge also acknowledged that the tight timetable was likely to result in injustice, but that the legislature must be assumed to have taken this into account. This principle has been applied by the UK courts on numerous decisions upholding adjudicators' decisions, even where clearly wrong on points of fact or law. Adjudication, by its very nature, can subordinate the right decision to a quick decision. Section 610 of the Act makes clear that the decision of the adjudicator shall be binding until the payment dispute is finally settled by the parties or a different decision reached at arbitration or in court. This will be a challenge for Irish courts, bearing in mind the constitutional position here, and it remains to be seen whether an approach similar to the UK will be adopted. Certainly, Mr. Justice Clark was of the view that it cannot be assumed that the precise way in which the Irish courts will approach issues arising out of adjudication will be identical to the way in which similar questions might be approached in the UK. I'll hand over now to Tom Pemberton, who will consider the provisions relating to payment and suspension of the works.
Thank you, Cathie, and good afternoon, everyone. For those of you who don't know me, I am a partner in Beale's construction and engineering team, specialising and advising on contract drafting, negotiation and compliance. Over the next 20 minutes or so, I will provide an overview of the provisions of the Act that deal with payment and suspension for non-payment. These provisions, whilst relatively brief, introduce a number of significant changes for those in the construction industry in Ireland. As Cathie has made clear, the payment provisions in the Act are based on similar concepts and principles to those in the UK Construction Act. However, there are numerous important differences. In particular, the Irish legislators chose not to replicate any of the revisions to the UK Act which were enacted in 2009 and came into force in 2011, with a view to improving the operation of the original UK Act. This was notwithstanding that the Irish legislators had a full opportunity to compare and contrast the pre-2009 UK Act with the post-2009 Act. Sections 3.1 and 3.2 of the Act require construction contracts to provide certainty as to the dates by which payments must be claimed and paid, and an adequate mechanism for determining the amount of the payments where these are not provided by the contract. It can be expected that many construction contracts concluded after 25th July 2016 will not comply with the detailed requirements of the Act. In these cases, the schedule will apply to the extent of such non-compliance. As I will explain shortly, there is a significant difference between the effect of the schedule on a main contract and its effect on a subcontract, which has no parallel in the UK Construction Act and which has potentially adverse consequences for main contractors. So looking at the schedule, it can be seen from the table that this consistently provides for a period of 30 days between interim payment claim dates and between the claim dates and the payment due dates, both for interim payments and for the final payment. I will say a bit more about the requirements with respect to payment claim notices and the responses to be made to them, if appropriate, shortly. The schedule also provides for the assessment of the amount of interim payments where there is no contractually agreed basis of assessment. As may be expected, the schedule provides that this is the aggregate of the gross value of the work done at the payment claim date, less any deductions from payment provided for in the contract, such as retention, and the amount paid to date. As I mentioned just now, there is a significant difference between the effect of the schedule on a main contract and its effect on a subcontract. As Cathie has made clear, main contracts include main consultancy agreements and subcontracts include subconsultancy agreements. So as Cathie has stated, the different treatment needs to be borne in mind by consultants as well as main contractors when negotiating the terms of their consultancy agreements and subconsultancy agreements. In the case of a subcontract, the schedule applies except to the extent that the subcontract makes provision which is more favourable to the subcontractor than the schedule. Accordingly, the main contractor is obliged to make payments to its subcontractors within the period prescribed by the schedule, i.e. 30 days, or the period provided in its subcontracts, if shorter. However, in the case of a main contract, the schedule only applies to the extent that it does not make provision for the matters specified in the relevant sections of the Act. Accordingly, if the payment period specified in the main contract is longer than that provided by the schedule, the longer period will apply. In this case, the main contractor will be obliged to make payments to its subcontractors before it is entitled to receive payment from the client. The implicit assumption is that main contractors are in a stronger position to negotiate shorter payment periods vis-à-vis their clients than the lower tier subcontractors are vis-à-vis the main contractors. Whether or not this assumption is correct, the legislation gives every incentive to main contractors and consultants to agree payment terms with their clients which are no less favourable than the schedule, in order to avoid negative cash flow in relation to their subcontract payment obligations. The greater degree of protection given to subcontractors than to main contractors in relation to payment is a reminder that a key driver of the Act was to improve cash flow below the Tier 1 main contractors and suppliers, as Cathie has highlighted. As Cathie has also highlighted, a centrepiece of the legislation is Section 3.5 of the Act, which provides that pay when paid provisions are ineffective. However, Section 3.5 is subject to an important exception and a further caveat. In the first case, pursuant to Section 3.6, effect will be given to a pay when paid provision in a subcontract where the client under the upstream construction contract becomes subject to an insolvency event as listed in that section. There is a similar exception in the UK Construction Act. Secondly, it remains possible for a main contractor to include a pay when certified provision in its subcontracts, and this on the face of it would not contravene the provisions of the Act. This situation reflects that which pertained in the UK under the pre-2009 Construction Act. The post-2009 Construction Act has made it clear that pay when certified provisions are ineffective. The Irish legislature chose not to include similar clarification. Accordingly, it can be expected that pay when certified clauses will proliferate, as they did in the UK after the original Construction Act came into force in 1998. If so, it can be expected that they will be subject to challenge, as they were in the UK. The case of Midland Expressway versus Carillion concerned a provision in a construction contract under the pre-2009 UK Construction Act, which made the subcontractors entitled to payment for variations subject to the contractor's equivalent entitlement under the upstream contract. The court held that this provision was inadmissible because it was an attempt to avoid the prohibition of pay when clauses, pay when paid clauses by circumlocution. This indicates that a pay when certified clause may also be held by the Irish courts to be contrary to the pay when paid provisions of the Act, depending on how it is drafted. It would have been helpful if the Irish legislature had removed any uncertainty by making it clear one way or the other whether a pay when certified clause would be effective. Section 4 of the Act provides that payment claim notices are to be delivered not later than 5 days after the payment claim date. Contractors and consultants should ensure that they serve payment claim notices within this time frame, since if they do not do so, it is likely that they will have to wait until the next payment cycle in order to recover payment for the month in question. Each payment claim notice must set out the amount claimed, the period, stage of work or activity to which the payment claim relates, the subject matter of the payment claim, and the basis of calculation of the amount claimed. For those of you who are consultants, we recommend that when negotiating a professional services contract, you agree at the outset with the client that your invoices will constitute the payment claim notices for the purposes of the Act, on the basis that they will set out the information required by Section 4. On a similar basis, for those of you who are contractors, you should agree with your clients that your applications for payment under your construction contracts are to constitute payment claim notices under the Act. Recent UK case law suggests that if you're intending to serve a payment claim notice, this should be made abundantly clear. So state in the document and in the covering letter that the document is indeed a payment claim notice. You should also ensure that you are fully aware of the payment requirements of the contract and of the Act, and that you serve your payment claim notices neither early nor late. If the paying party does not accept that the amount claimed is due, it must deliver a response within 21 days, specifying the amount proposed to be paid, the reasons for the difference between the amount claimed and its own assessment of the amount due, and the basis on which the amount proposed to be paid is calculated. If the matter has not been settled by the due date, then the paying party must pay the undisputed amount, not less than the payment due date. Therefore, the paying party has 21 days to contest the amount claimed. It is important to note that it is the amount that is due under the contract that will fall to be paid if the payment claim response is not served in accordance with the Act, not the amount claimed. This is consistent with the pre-2009 UK Construction Act, but does not reflect changes which were made in the post-2009 UK Act in order to promote payment certainty. Under the pre-2009 UK Act, where the payer failed to serve a withholding notice, there was still an opportunity to argue that the amount claimed should not be paid on the basis that it was not the amount due as calculated in accordance with the construction contract, as was held by His Honour Judge Humphrey Lloyd QC in the case of Alstom Signalling versus Jarvis Facilities in 2004. It can be expected that the Irish courts will adopt a dissimilar view in relation to disputed amounts under the Act, where a paying party fails to issue a payment claim response within the prescribed time frame. In this case, there may still be an opportunity to dispute the executing party's claim notice in an adjudication. This does not appear to be consistent with the overall objective of promoting cash flow and payment certainty. So the executing party's suspension entitlements are dealt with in sections 5 and 7 of the Act. I will focus in this section of the talk on section 5, which confers a right for the executing party to suspend work if the paying party fails to pay a payment due under the construction contract. Section 7 confers an equivalent right where the paying party fails to make a payment pursuant to an adjudicated decision. The two sections are similar in approach, so many of the points I make here in relation to section 5 can also be made in relation to section 7. Section 5 of the Act confers a right to suspend work under the construction contract where an amount due is not paid in full upon the date or by the date upon which it is due. The executing party may suspend work by giving 7 days written notice at any time thereafter. As may be expected, the suspension cannot continue after the amount due has been paid. The Act also provides that the suspension cannot proceed or continue after the other party has referred a dispute relating to the payment of the amount in question for adjudication. There is no equivalent to this provision in the UK Construction Act. Many commentators have expressed the view that this is a regressive provision. By comparison, standard building contracts commonly used in Ireland, such as the RIAI blue and yellow forms, entitle the contractor to suspend work with the right to terminate if, for example, payment is not made within 10 days. After the 25th of July 2016, if the client refers a dispute in relation to the claim in question to adjudication, the contractor must resume work notwithstanding the terms of the contract. Otherwise, it will face the consequences of being liable for the client's losses resulting from the suspension and/or the contractor's purported termination of the contract. The other key point to keep in mind is that the executing party's entitlement to payment is not to payment of the amount claimed, but the value of the work executed under the contract. Their entitlement. This means that if a dispute in relation to non-payment is referred for adjudication, and the adjudicator decides that no sum is in fact due, the suspension would have amounted to a breach of the construction contract. The risk of an adjudicator finding that the executing party was not entitled to suspend is underlined by section 5.7, which provides that section 5 is without prejudice to the other party's right to claim for compensation or damages for any loss due to a suspension that is unjustified in the circumstances. It should be noted that the consequences of suspension are less favourable to the suspending party than the equivalent provisions in the post-2009 Construction Act. In particular, although the period of suspension is to be disregarded for the purposes of computing the contractual time limit for carrying out the works and/or services, no allowance is to be made for any additional demobilisation and remobilisation time. Also, the Irish legislature chose not to replicate the post-2009 UK Construction Act provision to the effect that the party in default is liable to pay to the suspending party a reasonable amount in respect of costs and expenses reasonably incurred by that party as a result of the exercise of the right of suspension. Subsection 5.5 provides that if any subcontractor working under the executing party is affected by the suspension, the period of suspension will be disregarded in calculating the completion date for the subcontract works, notwithstanding that these may not have been affected to the full extent of the suspension period. This provision has no equivalent in the UK legislation, and is a further indication that the Act is intended to give a greater degree of protection to subcontractors than to main contractors. By way of conclusion, it is important that you take steps to understand your route to payment and that you ensure that your terms and conditions are updated to comply with the Act as necessary while protecting your cash flow. This is particularly important for those of you who are engaging subcontractors or subconsultants, bearing in mind that these parties will have the benefit of the minimum terms provided by the schedule. You should consider carefully the impact that this may have on your cash flow if in fact you're not yourselves being paid within a 30-day timescale. Meeting the requirements of the Act will affect your chances of success in adjudication. This reinforces the need to maintain proper records so that you as contractor or consultant are in a position adequately to vouch for the amount claimed in each payment claim notice. It is also important that payment claim notice and responses are served within the required timescales. You should flag up behaviour by the other party that does not comply with the Act. I will now hand over to my partner John Henderson. With the benefit of his experience of acting in adjudications under the UK Act, he will consider how to prepare for statutory adjudication in order to maximise your chances of success.
Thank you, Tom. As mentioned, I'm going to make some practical points about adjudication arising out of our experience of representing parties in the UK over the last 20 years or so. Adjudication is intended to be a straightforward and cost-effective method of obtaining payment. Our view is that, properly used, it can be exactly that. A claiming party that is properly prepared and has taken time to allow the Act to follow the Act and the Code should not need to be represented by lawyers and therefore will not incur that cost. If the claiming party is successful in recovering payment of the sum claimed, it should expect that the adjudicator will order the responding party to pay the adjudicator's costs of the adjudication, and therefore it should be a very cost-effective as well as quick process. In this part of the webinar, we will assume that we are a party to a construction contract, that we are owed money under that contract, and that we are going to represent ourselves without instructing solicitors. What are the practical considerations that we should take into account? I will break the answer down into 4 stages, generally following the progress of a dispute in adjudication. First, we will start with the primary and dominating consideration. Do we have a dispute relating to payment? This is the phrase used in the Act. The definition of what amounts to a dispute in UK construction law, especially in respect to payment, is very wide, and almost any request for payment that has been refused or which has not been answered in a reasonable time will be sufficient to qualify as a dispute. Therefore, we will assume that we've submitted an invoice and served the requisite notice, and we've not been paid. We might even have sent a final demand which has been ignored, and therefore we're confident that we have a dispute. Next, we need to know what it is that is included in and excluded from the definition of relating to payment. This is very important, as it may mean that various defences put forward by the employer, such as a counterclaim against us for the cost of delay or a counterclaim for damages arising out of alleged professional negligence, are either included in or excluded from the scope of the dispute. Whether they are included or excluded will have a huge effect on our preparation for and conduct of the adjudication. The Act doesn't define what it means by relating to payment, and it is open to interpretation. Interpreted at its narrowest, a dispute relating to payment is limited to whether or not we have satisfied the basic steps in order to trigger an entitlement to payment. That is, have we done the work claimed for, submitted an invoice, and submitted the appropriate notice? This narrow interpretation would exclude any claim of set-off for damages by the employer, and it would also exclude, for example, any counterclaim for liquidated damages on grounds that these are related to delay and not related to payment. The narrow interpretation would obviously suit us, as it limits the defences that the responding party can put forward as to why it has not paid. Alternatively, the widest interpretation of the phrase "any dispute relating to payment" includes consideration of all the defences that are available to that claim, or at a reasonable minimum, all the defences that have been put forward in the response to the payment claim notice. The risk to the claiming party, for example, is that the employer has made, say, an allegation of professional negligence against it in its response to a payment claim notice, simply as a way of trying to stifle a legitimate claim for fees. In that case, any claim in adjudication may very well involve expert evidence and could be expensive and difficult to deal with at short notice. It also means that a potential claim for negligence had to be notified to our insurers with all that entailed. The obvious practical approach is that we should take until the courts have decided the correct interpretation of the phrase is, so far as possible, to simply stay away from bringing claims in adjudication where the employer has a good and complicated defence. Having decided that there is a dispute relating to payment, and having considered the extent to which, if at all, the responding party has a defence to it, we can go on to consider the wider context of the claim for payment, and also our strategy in recovering payment. This involves looking at the contract, the project, and the Construction Act. Looking first at the contract, we need to be sure that it is a contract for construction operations as defined in Section 1 of the Act, and that it is not excluded from being such a contract under Section 2. For example, it's not excluded because the value is less than €10,000 or because it is a contract with a private homeowner. Most normal contracts, subcontracts and consultants' appointments will be contracts for construction operations. However, it is always important to check in the case of any uncertainty. Beyond this requirement, there are no formalities. Section 1.1 of the Act states that a construction contract does not have to be in writing for the Act to apply, and therefore, even if we have entered into an informal agreement under which we have provided construction works, or even if the employer has refused to sign a contract, we're entitled to take the benefit of the Act. If there is a written contract, we might want to look at the dispute resolution clause. Many modern construction contracts have tiered dispute resolution processes, beginning with meetings between senior managers of the parties, followed possibly by mediation, and then by adjudication, and then by arbitration or litigation. We would look at this clause as part of our wider strategic plan as to recover payment, because it may well, for example, suit us to talk to the paying party before launching an adjudication. However, we are not obliged to do so, as the Act makes it clear that we may adjudicate at any time, so long as there is a dispute. The great benefit of this to us is particularly combined with the right to interim payments under the Act, means that we do not have to wait until the end of the job to recover the money due to us. Experience shows us that recovering money at the end of the job is more difficult and more expensive than recovering during, and we should be ready to use adjudication accordingly. There is now no reason to carry on working without being paid. Having reviewed the contract, we should look next at the project and consider why we're not being paid and whether or not we'd be better off suspending under the Act, or whether we may want to suspend following the adjudicator's award. If there's a long way to go on the project and we're dealing with a repeat employer, then we will obviously need to be very careful to characterize the adjudication as a straightforward part of the contractual apparatus and try to make it as unadversarial as we can so as to preserve the working relationship. With planning and diplomacy, this is usually reasonably straightforward, and even if our employer doesn't like it at the time, experience suggests that employers can learn to live with adjudications. Finally, in respect of context and strategy, when preparing our claim in adjudication, we will also want to consider the other provisions of the Act, particularly the obligation to serve notices and to make sure that we've properly complied with it, and also to consider what is going to happen after the adjudication if the employer still does not pay. Are we going to incur the cost of applying to court for enforcement, or would it be preferable to suspend? Once we're confident that we have a dispute, that it's appropriate to adjudication, and we've thought through context and strategy, the next step is to start the claim in adjudication. The Code of Practice that is referred to in Section 6 of the Act contains clear guidance on what should be done. It is a straightforward and clear document and should be followed carefully. Broadly speaking, starting an adjudication involves 4 stages. 1. Serve a notice of intention to refer. 2. Appoint an adjudicator. 3. Serve a referral notice. And 4. Have the adjudicator set a timetable. I will comment on each of these stages. The notice of intention to refer a dispute to adjudication is only a summary of the key points of the claim. It is not the full claim document. That comes later. In some adjudications that I've been involved in, the notice of intention to refer is only a couple of pages long. As long as it contains the basic requirements set out in the code, that is enough. The crucial requirement for the notice of intention to refer is that it should define the dispute that is being referred to adjudication. The definition of the dispute is usually set out in a list of decisions that we're asking the adjudicator to make. The adjudicator has no power or jurisdiction to decide any dispute except that described in the notice of intention to refer. Therefore, it's important to think through and phrase the requested decision carefully. For example, a couple of practical consequences of this are, first, that we should be reasonably careful as to how we define the claim. If we claim, for example, €10,000 of unpaid fees, and the adjudicator finds that we are only entitled to €9,000, he may conceivably be unable to award us €9,000 because that is not defined in the dispute. Whereas, if we were to have claimed €10,000 or such other sum as the adjudicator may award, then he does have jurisdiction to award us €9,000. As a second example, it may be that by careful definition of the claim, we can exclude from the adjudicator's jurisdiction some of the responding party's more problematic defences. As a very simple example of this, if the responding party's defences only relate to part of the claim for payment, then it may be that we simply do not bring that part of the claim in our notice of intention to refer. The second of the 4 steps is the appointment of the adjudicator. Again, this is explained in the code. The key point is probably to try to obtain, by agreement or representations to the appointing chairman, an adjudicator who is appropriately qualified to deal with the dispute at hand. It's no use appointing a lawyer to deal with a dispute arising out of details of a bill of quantities, any more than it is worth appointing an engineer to decide the legal interpretation of a contract. The third of the 4 steps taken to start an adjudication is the service of the referring party of its referral notice. This is the document in which the referring party fully sets out its claim. It is probably the referring party's single most important document in the whole exercise. It should be clearly written and fully supported by all the documents that the adjudicator needs to see to decide the dispute. When preparing an adjudication, I normally like to have the referral notice ready or almost ready even before the notice of intention to refer is served, and I like to use it as an internal test to see whether I can make out a good argument in support of the referring party's claim. It should be drafted so as to persuade the adjudicator by reference to factual evidence and legal arguments as to the strength of the claim, and it is always sensible to avoid gratuitous provocation and excessive indignation in respect to the conduct of the employer who has not paid, however frustrating that conduct may have been. The 4th and final step in the start of the adjudication is that the adjudicator sets the timetable for the rest of the adjudication. Again, think about this in advance and make suggestions to the adjudicator as to what might be helpful and beneficial to your own side of the argument. For example, if you believe that a site meeting would be helpful or some other step would support the claim you are making, then suggest that the adjudicator includes this in his timetable. Once the adjudication has begun and is being carried out in accordance with the adjudicator's timetable, you need to consider the general conduct of the adjudication. Two broad issues arise. First, the issue of jurisdiction. In general terms, jurisdiction covers what it is that the adjudicator has power to decide. For example, under the Act, disputes with residential homeowners or arising out of contracts where the price is less than €10,000 are excluded from the Act, and therefore an adjudicator has no jurisdiction to hear disputes arising from them. Likewise, if a dispute arises from a contract which is not a contract for construction operations, or arises from something which does not relate to payment, or if the relief sought is not set out in the notice of intention to refer, then the adjudicator has no jurisdiction to make a decision. Disputes about jurisdiction between parties during adjudications are very common. However, the adjudicator has no power to decide on his own jurisdiction. If an adjudicator felt that there was a clear and obvious lack of jurisdiction, he might well consider withdrawing from acting as adjudicator. Otherwise, what tends to happen in the UK is that a party raises a jurisdiction argument and then reserves its rights to raise that argument again if and when the adjudicator's decision goes against it and that decision is enforced in court. Our practical experience in respect of jurisdiction points is that unless they are very significant, then it is usually best to spend the limited time available during the adjudication working on the substantive arguments rather than spending a lot of time puzzling about jurisdiction. Simply reserve your rights and deal with the real dispute. The second broad issue is procedural fairness. Under the legislation, the adjudicator is under an obligation to be procedurally fair. This probably includes setting a timetable that gives both parties reasonable opportunity to respond to the other and setting a procedure which is appropriate to the dispute. For example, if the heart of the dispute is a difference of facts between the witnesses, then it is probably procedurally fair to have a meeting to hear both parties' witnesses. Another part of procedural fairness is that communications between one of the parties and the adjudicator should always be seen by the other party so that it is fully informed about how the matter is being dealt with. Therefore, when you communicate with the adjudicator, you should always copy your emails or letters to the other side. If you think you're suffering from some procedural unfairness for any reason, then it is probably appropriate to write to the adjudicator, copied to the other party, explaining clearly what the problem is. If it is a significant problem and you're suffering real prejudice, then it's probably appropriate to invite the adjudicator to withdraw from acting. If it is less serious, then you might simply reserve your position and wait and see how the outcome of the adjudication unfolds. Overall, our experience is that most adjudications are reasonably straightforward, and in the vast majority of cases, the parties accept the adjudicator's decision and then get on with the rest of the project. Whilst there are exceptions, adjudication is usually cost-effective and time-effective method of resolving payment problems and freeing up cash flow. From our experience, we unreservedly recommend to you that you familiarize yourself with it and learn how to use it. Start with an easy dispute with a relatively low value and learn from experience. Operating the procedure will soon become second nature and will benefit your business and the industry generally. I'm now going to hand back to Cathie to conclude the webinar.
Thank you, John. Just to wrap up, it's clear that the Act has the potential to allow for the introduction of cultural change within the Irish construction industry. Whilst there are a number of question marks remaining as regards adjudication in particular, we believe its introduction to be a positive development. This is a topic that will continue to interest those in the industry, and certainly we propose to have a further webinar on this once the Act is bedded in and we're in a position to draw some conclusions on its progress and whether it's having the desired effects. If you're interested in receiving an invitation to our next webinar, please do not hesitate to let us know. It remains for us to say thank you for listening, and please do not hesitate to contact us in relation to the issues raised. Once again, thanks for listening.